Morning students, I am Dr.A.RADHAKRISHNAN, Assistant Professor, PG Research Department of Commerce, St.Joseph College of Arts and Science, Autonomous, Cuddalore 1. Today's subject, Legal Environment of Business. Topic, the Rules and Regulation Law relating of Transfer of Property. First, what is meaning of property? The property definition describes it as anything over which a business or a person has lawful rights. They may have some enforceable privileges over the items. Most of the properties contain present or future monetary value, and that is why they are considered asset. Property could be defined as any item over which a business or a person has legal privileges. Property could be a tangible items such as a car, furniture, industrial equipment, etc. Or could be an intangible item, stock, patent, etc. Then the types of property. First types, the real properties. The most familiar type of property is real property. It contains land, building that occupy the land, as well as the privileges to use the land. The central point of real estate is real property, and it deals with transactions such as buying, renting, and selling the property. It also deals with concerning the use of land and building for commercial and residential purposes. And second types, personal properties. We know the personal property as real property, but it is different because real estate is not included in it. Personal property could be transferred physically to someone, and it is not always attached to the land. It may include automobiles, tools, clothing, etc. And third one is government owned property. The government owned property including resources, tangible as well as intangible assets, and real property. Most of the properties owned by the government or public property. Some examples of government owned properties: their public school, city park, and public libraries. These properties are owned by the government but are available for the public to use. However, every property owned by the government cannot be accessed by the public. In some cases, even the property accessible to the public is not available to them. For example, if a city park is under curfew, then it cannot be accessed by the public. The public cannot have access to government-owned properties such as a lab or military research facilities. In some cases, a property owner would sell his property to the government. And fourth one is private property. A property that is possessed by an individual or a private entity is known as private property. It may include real property, personal property, and tangible as well as intangible assets. Mostly private property is classified under real or personal property, but every real or personal property cannot be private property. Neither the government owns the private property nor it is accessible to the public. However, in some cases, the government would undertake the ownership of private property in certain situations. And other types of properties, movable and immovable properties, and second, tangible and intangible properties, third, private and public properties, 4 personal and real properties. Fifth one is corporeal and incorporeal properties. First, the movable property and immovable properties. Movable properties is that which can be easily moved by a human effort from one place to another place without causing damage to it. In simple words, we can say that movable properties is such property that can be possibly transferred from one place to another places with a human effort. Immovable properties. Immovable properties means such type of property which cannot possibly be moved from one place to another places. This type of property directly connects or attached to the earth. Tangible property and intangible properties. Second one, tangible properties and intangible properties. Tangible properties means such type of property which physically exist and that anyone can touch or feel. Such type of property can be easily moved by human efforts. Such type of property cannot be direct attached to the earth like immovable property. Intangible properties. The intangible properties mean such type of property which does visible not exist that way no one can feel or touch it. However, it has some value. Such type of property can call personal property too. The owner of such property has the right of enjoying and using it. If we see the example of such properties, we can say that negotiable instruments, bonds, securities, patents, trademark, shares, etc. we can call intangible properties. Then the Transfer of Property Act 1982 provide for certain rights and properties which cannot be transferred. They are maintained below. Space successions. A more possibility of an heir succeeding to an estate is excluded from the category of transferable property if the person is not totally sure whether he will be receiving the property from the third person. Then he cannot transfer it until he gets the ownership of the properties. For example, if a person A, while assuming him to be a legal heir of a property, cannot transfer that property unless he gains the ownership of the property and the property belong to him. And the right to issue, right to sue. Since a right to sue is the personal right of the property aggrieved, therefore the right of suing cannot be transferred any person. B can sue in the court of law. He cannot transfer his right of suing. The easement. An enhancement is a right which comes to the property itself. For example, a passage is front of the enhance in the house as in enhancement to the properties. Public office. 4. Neither the public office nor the salary of the public office can be transferred before or after it is been payable. The profession is based because the public office is held for personal qualities necessary to fulfill, for example, judge, inspector, etc. And fifth one is pensions and stipends. The pension means a periodical allowances or stipend granted not in respect of any right of office, but on account of past services or particular merits. Stipends allowed to military, naval, air force and civil pensioners of the government and political pensions cannot be transferred. Right of re-entry. The right of re-entry means a right to resume possession of the land which has been given to another person for a certain time. It is usually installed in lease, empowering the lessor to re-enter a breach of covenants in the lease. For example, a grant a lease of land for 5 years to B, with the conditions that B shall not dig the land B. The future maintenance. A rich, the maintenance is only for the personal benefit or the owner, thus cannot be transferred. Eighth one is nature of interest. The nature of transfer is forbidden in certain circumstances. For example, res communis means the thing of which no one in the owner and may be used by all the men. Res millions, thing belonging to nobody, etc. can be transferred. Next, the sales. Provisions of sale. First, what is meaning of sale? A contract of sale of good is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. There may be a contract of sales between one part owner and another. A contract of sale may be absolute or conditional. Then the importance provisions of sales contract. First one is the first importance price. Make sure the correct prices is listed. Any discount, installation charges and delivery charges should all be included. Price adjustment. If you are entering into a long-term contract, consider how price adjustment will be handled. Taxes. Payment and credit terms. State when payment is due. Of payment is not required immediately. Spell out payment terms including any discount or early payment or finance charges for late payment. Warranties. Ideally, you want to have limited warranties, but improving on the standard 90 days warranty may give you a leg of 1 year competitions. Disclaimer. Most sales contracts contain the following standard disclaimer. There are no other warranties expressed or implied, including mercantility or fitness for a particular purpose. Limited liabilities claim. A sales contract should attend to limit your liability. A typical clauses for liability states that the seller's maximum amount of liability is equal to the purchase price. Although clauses that limit liabilities aren't always enforceable and won't necessarily hold up in court, there is no harm in including sentence that states are you are not responsible for conditional damages, benefit and speculative damages or lost projects.